Five seconds. Start feeling aggrieved and dissatisfied with the impugned judgment and order dated 13/8/2016 passed by the High Court of Delhi at New Delhi in writ petition number 1034/2015, by which the High Court has allowed the said writ petition preferred by the private respondent herein original writ petitioners, and has declared that the acquisition proceedings initiated under the Land Acquisition Act 1894 herein after referred to as the Act 1894 clause in respect of the subject lands are deemed to have lapsed under section (2) of section 24 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 herein after referred to as the Act 2013 clause. Delhi Development Authority (DDA) and Government of NCT of Delhi have preferred the present appeals stop. Private respondents number 1 and 2 herein original writ petitioners filed the writ petition before the High Court for a declaration that the acquisition proceedings initiated under the Act 1894 in respect of the subject lands are deemed to have lapsed under subsection (2) of section 24 of the Act 2013 stop. It was the case on behalf of the original writ petitioners before the High Court that as the possession of the land in question is with them and no compensation has been paid, the land acquisition proceedings are deemed to have lapsed stop. Heavy reliance was placed on the decision of the High Court in the case of Pune Municipal Corporation and others versus HMS and others (2014) 3 SCC 183 stop stanza. The petition was opposed by the appellants herein and others stop. It was the specific case on behalf of the DDA that as such the compensation was tendered to one Shiv Kumar, son of Devi Chand stop, relying upon the decision of the High Court. In the case of Pune Municipal Corporation (Supra), the High Court by the impugned judgment and order has allowed the said writ petition and has declared that the acquisition proceedings initiated under the Act 1894 in respect of the subject lands are deemed to have lapsed under subsection (2) of section 24 of the Act 2013 stop. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court, DDA and Government of NCT of Delhi have preferred the present appeal stop stanza. Learned counsel appearing on behalf of the DDA has vehemently submitted that in the facts and circumstances of the case, the High Court has materially erred in declaring that the acquisition proceedings have lapsed under subsection (2) of section 24 of the Act 2013 stop. It is submitted on behalf of the DDA that in the present case, as such the possession was already taken over by the authority on 23/9/1986 after following the due procedure as required, and even a Panchnama was also drawn, which was the requirement while taking over possession stop. It is urged that even the compensation was tendered to the recorded owner Shiv Kumar through notice under section 12(2) of the Act 1894, but recorded owner never came forward to accept the same stop stanza.